to cut the long story short, let's see what are your recommendations regarding the adoption of the new law in Montenegro, based on your personal international experience and your work in the region and in the European Union.
Maybe I shall start then.
First of all,
thank you very much.
That's the best thing.
Yes. Thank you very much for the invitation this afternoon to discuss a topic that has been of interest to me for probably the last 20 years. My name is Jill Thomas, and I am currently an asset recovery technical assistance advisor, supporting the development of all aspects of confiscating criminal proceeds across various regions of the world. Currently, I'm working in West and Central Asia, the Middle East and North Africa, and I have some extensive work in the Balkans. My background is in law enforcement. I have over 30 years experience as a criminal and financial investigator. However, the reason I've been asked to participate in this panel is that for the last 11 years of my law enforcement career, I managed the Europol Criminal Asset Bureau, so the European Asset Recovery Office, if you like. Supporting investigation teams in Europe to trace and identify assets located outside of their national boundaries for cases involving a serious and international crime. During this time, I also managed the Secretariat of the Asset Recovery Network, the international network of practitioners, called CARIN, and actually currently I manage the Balkan International Asset Management Network called BAMIN, to which Montenegro is also a member, in fact a member of both of those groups. And I think I will talk about international cooperation for civil forfeiture in a moment. There's been some mention today already about the relevance of Europe in this topic, and specifically the relevance of the EU Commission. And I coordinated the activities of the asset recovery offices in Europe and the important work within the European Union on the development of asset recovery law and policy, including the issue of civil forfeiture. And finally, I was very fortunate to be involved in a research topic as part of my own private academic work, my master's degree in international criminal justice, with a thesis that studied the introduction and implementation of non-conviction-based confiscation in the European Union. This was in the late 2007, 2010, when this topic was really in the primary stage of discussion in the European Union, and there was some extremely interesting revelations that came out of that study. But I will focus more this afternoon on the international view of civil forfeiture. And one of the things I was asked to explain was that, in my opinion, what changes should Montenegro make in terms of legislation based on the international landscape, both in the European Union, also in the Balkans, but also across the world. And I think in order to do that, it's important to explain that there have been 4 types of non-conviction based confiscation elaborated by the practitioners in this field. I will just briefly explain these 4 models, but the reason why the practitioners came up with these 4 models is that I heard this morning that the Minister for Justice said that this was a revolutionary approach of civil forfeiture, and certainly for Montenegro it is revolutionary, but fortunately for Montenegro it is not revolutionary necessarily for the rest of the world. And practitioners have been talking about this topic, developing their legislation since the early 2000s. And as a result of that, there were some difficulties that emerged in international cooperation. Because as our previous speaker before the break indicated, it's very important for jurisdictions to adopt legislation that suits their own legislation and institutional structures and their own constitution. Extremely important, not to just take an off-the-shelf type of legislation. But as a result of that, and as a result of the various types of non-conviction based legislation that have been adopted, international cooperation became extremely difficult. So in order to help that, the practitioners involved in international cooperation came up with 4 models so that they could support each other when one jurisdiction made a request for its confiscation order to be enforced in another jurisdiction, and that confiscation order was based on a civil forfeiture type of legislation. And this is one of the challenges that Montenegro will come to face. And those 4 types of non-conviction based confiscation are as follows. First of all, there is the confiscation of property during a criminal prosecution when the prosecution itself cannot be concluded for one reason or another. And Montenegro has this in its legislative toolbox already in the case of death of the defendant, or when the instituted proceedings cannot be continued due to the existence of some circumstances which preclude the prosecution. And this is the most common type of non-conviction based confiscation. Most jurisdictions will have this in their criminal codes. The second, and we've heard about this as well today, because Montenegro, together with all the other jurisdictions in the Balkan region, have this extended confiscation, or also referred to as enhanced confiscation, which is where assets are confiscated and these assets are not connected to the offence for which the defendant is before the court. And under a number of different circumstances, it may be that the court makes certain assumptions, or it may be that the confiscation is based on a disproportionate amount of funds between legal income and assets owned. And Montenegro has this, and we heard from the President of the High Court this morning that yes, it does have it, but it has experienced considerable difficulties in implementing extended confiscation, and there may be several reasons for that. The third model is in fact the civil forfeiture in rem action, against the property, not the person, which we've heard about today. And this is more the classic civil forfeiture that jurisdictions tend to talk about. And then the fourth model is the unexplained wealth model. And this is an approach whereby it's also an action against the property, not the person, but that there is a disproportionate value between the assets that are owned and the legal income that is being earned by an individual, and the confiscation is based on that disproportionality. Now, those four models may happen in the criminal process or the civil process. So, for example, model type 1 and extended confiscation type 2 generally happen in a criminal procedure, whereas the civil forfeiture type 3 is a civil approach, and type 4 is generally civil, but there are jurisdictions, particularly in Latin America, that have criminalized their unexplained wealth provisions. And in fact, France has also made it a criminal offence to own unexplained wealth. Now, these are not absolute, clearly defined types. Jurisdictions have adopted maybe one or two of them, or maybe their extended confiscation may have some aspects of civil proceedings within it, such as within the UK, and we'll hear a bit more about that in a moment. But what I would encourage Montenegro to do is to continue to develop its laws in a direction that allows for as many different types of confiscation as possible. There are many jurisdictions that have all four models of non-conviction based confiscation, in addition to their classic conviction based laws for confiscation. Montenegro currently has the first two, the confiscation of property when the prosecution cannot be concluded, and, as we've heard, the extended confiscation. It's now considering further provisions that include civil forfeiture, and I would encourage the continued development of those. I think probably my colleague Tristram Hicks will add another type of confiscation to those four in a moment, but just to finish off in relation to the models, I would also remind our Montenegrin colleagues that this does not happen overnight. The UK's Proceeds of Crime Act has existed for 20 years now and is still continuing to develop, and recently has introduced certain new provisions that have made it even more effective. And sometimes the provisions that are introduced are not as successful and they need a little more work. And perhaps that is the case for Montenegro's extended confiscation legislation, even if that work is in the area of implementation rather than amendments to the law. So one other area before I pass over to my colleagues, I don't want to take all the time, one other area I was asked to just mention was what tools are available to Montenegro in relation to international cooperation when it has finally adopted its civil forfeiture laws. And I would split this question into two. When you are seeking to confiscate assets, the first thing you have to do is find them. If you don't find any assets, then you will find it difficult to confiscate at the end of your case. So financial investigation tends to work very smoothly internationally, as smoothly as criminal confiscation financial investigation does. There are certain international networks to which Montenegro are a member that will provide them a platform, a legal platform, and a secure platform to exchange information for financial investigation for civil forfeiture. And the Montenegro police have a contact in the Karen network, as does the Special Prosecutor's Office, also have a contact in the same network. The more difficult area, as I have already alluded to, is in terms of the recognition of orders to enforce for sequestration and confiscation when those orders have been made based on civil proceedings. Some jurisdictions have difficulty in recognizing these orders when they themselves do not have a legal system that allows for civil forfeiture or civil unexplained wealth. However, what I would say to our colleagues, our prosecutors in Montenegro, is please, all is not lost. There are a number of international cases that have been successful. There's a very famous case called the Crisafulli case, which involved the courts in France recognizing and executing a foreign non-conviction based confiscation order from Italy, that even though France does not have that type of legal regime. Countries are, by international standards, encouraged to look beyond the terminology that's used by requesting jurisdictions and examine if the cooperation that has been sought meets the legal requirements of its own domestic legal system, and to respond. And perhaps a final thing I will say in terms of international cooperation is that although the European Union are looking very closely into an instrument, a regional instrument for civil forfeiture, there is not one yet. The international standards that exist encourage jurisdictions to enforce orders based on non-conviction based civil forfeiture requests. So there is clearly an indication there that this is a developing and a growing type of legal mechanism, and that countries are encouraged to recognise and respond to orders and requests when they're made. I think I'm going to leave it there and maybe pass over to back to our moderator for the next panel member.
Thank you, Ms. Thomas. Now we'll hear Tristram Hicks, the expert for the recovery of assets gained through or acquired through organized crime. Can you hear us?
I can, Peter. Nice to see you.
Dobar dan. Hvala što ste se nama. Počet ću ovim pitanjem. Kako mislite...
Being with us, I'll start with a question. What should be the priorities or priority cases? What would you suggest in this regard? So what are the lessons learned through evolution of these laws and legislation, judging from your experience, international experience, I mean?
Okay. Thank you for the question. Thank you, Jill. Good afternoon, everybody. I'll give a quick introduction of myself, and then I will answer the question, and then I'll hand over to Barbara. My background is as a police officer. I was a police colonel rank. I was in charge of all of the police financial investigators in London. The evolution of the law in the UK was revolutionised in 2003 by a new law. And the evolution before that was a story of legal and practical failure. And when the new law came in, it became a story of success. And I happened to be in charge of the financial investigators, the very few financial investigators in London when that happened. I should explain that the police in the UK have a different role from Europe. A police officer like me, I would decide what would be investigated, who would be investigated. I would authorise special techniques. If I needed a prosecutor's help to freeze assets, then I would contact a prosecutor. But essentially, everything belongs to the police. We do the investigation, we hand over to the prosecutor to present the case in court, according to the criteria that Rupert told us about an hour ago. So the police role is quite different. When the law changed in 2003, the UK formed a national implementation committee for the new law. And because of my role, I became a member of that committee, which then carried on for the next 10 years as the law evolved and as we solved the practical problems that were presented to us by implementing a new law using a system which had a history of failure. So I'm going to talk about the evolution a little. So the previous law started in 1986, and there were a number of changes for the next 15 years which more or less failed to deliver the tools needed to make the law work in a practical way. And the law of 2003, the Proceeds of Crime Act, was a comprehensive revision, a revolutionary revision, which provided, as Jill put it, all four methods of asset recovery, of non-conviction based confiscation. All of those were available all of a sudden. And there was a fifth power specific to England and Wales, but it also exists in Ireland and has done for many years in the United States, which is the in rem possibility to confiscate cash, by which I mean folding paper money. A specific power to litigate cash which has been found by the police on the balance of probabilities. And this was the key power that moved us from failure to success. Now, the reason for that is because the cash confiscation power provides quick seizure of cash, quick litigation by the police, so not by the prosecutor, but by the police, on the balance of probabilities in the criminal court. And the reality of that is you get very quick results. And that changed everything in the UK. We started with poor law that did not work. We started with low capacity. I was in charge of only 25 financial investigators in a city of 10 million people. That's all we had. And the cash allowed us to test easy cases against ordinary criminals in the courts, so that when they were appealed, And when they were linked to crime, as they often were, then prosecutors would get experience of dealing with easy cases of asset recovery at a practical level, which is what Rupert was saying earlier. His recommendation was that the powers should be used by ordinary prosecutors in ordinary cases. And I strongly agree with that. And it was the cash seizure power that allowed us to do that quickly and get quick results. Furthermore, the cash, or most of the cash, was ploughed back into the police and prosecuting agencies. So we solved the capacity problem of very few investigators by buying more using the cash. And although, yes, it is a specialist area in confiscation, we found that we could take good, experienced detectives and train them in financial investigation, and that produced excellent results quickly. So that's the main thing I wanted to say. My recommendation for the new law is that Montenegro should consider having a law that offers all four systems, all four models that Jill identified, plus the cash seizure model as well. Because this has a history of success. We know that it works for decades in a number of different jurisdictions. And I should just add that the United Kingdom is actually a number of different legal jurisdictions from a criminal law perspective. And the different models that Jill outlined had different successes in the different parts of the kingdom. So in Southern Ireland, which is an independent country, the tax measures were the most effective tool against organised crime. In the north of Ireland, the in rem confiscation against assets was the most successful thing. In England, the most successful power was cash seizure, and cash confiscation still makes up between a quarter and a third of all of the assets that were recovered in the United Kingdom. So different environments, different societies produce different results, which is why I recommend that Montenegro considers having all the options. Why not have the whole toolbox? And then you can choose what works and see whether it does. So that's my strong recommendation. And finally, to give an idea of the difference between failure and success, under the old law in the UK, all of the agencies in the United Kingdom recovered about 15 million euros per year. So throughout the 1990s, only 15 million euros was recovered from what is a very big and a well-provisioned country. After the new law, the amount recovered doubled every 18 months to reach a total of 200 million euros every year. And that's still the case now. Now, personally, I think we could do better. But that was the change that I want to emphasize. We went from 15 million to 200 million. The reason that happened was because of the cash seizure power, the choices available to litigate assets, and the fact that we had an implementation committee to work through the problems as they were discovered. So we mapped out the legal system, and as we discovered things didn't work in the chain because no one used a lot of the administrative powers, we didn't use them in many of the agencies, that implementation committee fixed the problems as we went along, and it was a critical success ingredient. That's enough from me. I know Peter's got some more questions for us, and I hope that this will become more of a dialogue and more of a discussion, less of a monologue from me. But thank you so far.
Hvala najljepše. Na vezi imamo I Barbaru Lipovšek.
Thank you so much. We have Barbara Lipovšek, special prosecutor from Slovenia.
Dobar dan. Dobar
Good
dan.
afternoon. We're pleased to hear you. I hope you can hear me so I can start. We have a few questions before you start. I will just perhaps give you some guidelines and then you can proceed. We heard in the introductory panels some skepticism of some people regarding challenges and this also protection of human rights, because we are here making pioneering steps after 30 years and we have to rely on weak potentials in the prosecutor's office. So what are your suggestions regarding legislation and what we should do, and what are your experiences? Thank you for your questions. Everything that you have just mentioned is something that I was going to say about, but I'm Barbara Lipovšek. I come from Slovenia. I'm a specialized state prosecutor at the Specialized State Prosecutor's Office in Ljubljana in Slovenia. Regarding forfeiture of assets, I have worked for a long time, actually since the beginning of my career within the Special Prosecutor's Office. That's since 2012. Before that, I was a district prosecutor in the District Prosecutor's Office in Celje, the town in Slovenia. And before that, I worked in the state, in the ombudsman. And before that, I worked in a multinational company. So I have experience in this, with this very important field. And all these things have helped me in the job I'm doing now. In Slovenia, there is a special law. We don't have the Institute of Forfeiture of Criminal Assets is not a part of the criminal code. It's a special law. That law was adopted in 2011. So in practice, we started working on it at the beginning of 2012. And we have crossed this path that's been very specific, because it was the first time in history that prosecutors were forced to work on the segment of civil law on the highest level. It's normal that in prosecutor's office we'll deal with different procedures, but this was a sort of a mixed up system that was not clear to us at the beginning. But when I look backwards, I think that the way things function in Slovenia were already defined well at the beginning. And I will describe the main problems and how we overcame them. And before I explain that, I just want to say that in Slovenia, we use the so-called cascade approach. We take into consideration the assets acquired through criminal proceedings. We have this extended confiscation, but a little bit more limited than in Montenegro. And then the third one is in a REM procedure, which is defined by a special law. And the fourth possibility that we have in mind is that we see that these in REM procedures don't seem successful. We resort to the tax approach procedure. I don't know how to explain it, but when the tax administration collects taxes and there is a situation that somebody has more assets that they could really earn, then but it still doesn't have anything to do with the criminal procedure. What is the characteristic of our procedure, which which entered into force in 2011, but we started working on it in 2012, and it was already amended in 2014. Perhaps in the introduction, you can tell us, because we heard in the previous panels that one draft of the law was not accepted by the Constitutional Court. So what was the reason for that? Perhaps we can still find some time to avoid some problems that you had in your initial stage. I understand what you mean. What you should pay attention to is the difficulties that we had in Slovenia as well. This law, in its first draft, when it entered into force, actually, it had a provision that we can do financial investigations from the 1st of January 1990. So that was the provision that was the Constitutional Court said that it was a retroactive approach and it had to cease to be valid. And in 2018, we had to actually terminate 11 or 12 proceedings that were already before the court. So we had to terminate all those proceedings, and also we had to pay all the costs that the parties had before the court. So I think that it is very important for every law, and we have learned a lesson from that, is that the law must clear time of entry into force. So when these things, the investigations can start, because already in 2012, lawyers said that that provision was unconstitutional. We got the constitutional decision 10 years later, which is a long period. And if you have these limits clear at the very beginning, then you can have more successful examples. But by all means, we are satisfied with the development of this institute. Why I mentioned development? Because it's a new area for prosecutors, and every institution should do its best to develop this institute. We still monitor all those problems, shortcomings, everything that can help us to accelerate the investigation procedures, also all the evidence we can present before the court, so that we can have court decisions in favor of the state of Slovenia. What could be also a recommendation? We have 2 or 3 constitutional decisions. The first one was this retroactive approach, which drastically influenced our proceedings. There was a decision from 2017, I think, which showed what could be confiscated in the civil procedure. The procedure is divided into two stages. The first one is the financial investigation, which is limited to a year and a half. So if the financial investigation yields results, if there is illegal source of assets in the civil proceedings before the court, we ask the entity, the person, we actually confiscate the person's assets. But another decision of the Constitutional Court said that we cannot confiscate anything else except what the person gained during the financial investigation. And in financial investigation can cover the period of not more than 5 years from the moment from the time when somebody committed a criminal offense until now. So if the first decision of the Constitutional Court said that we cannot start anymore from the 1st of January 1990, but on the 29th of November 2011, that's when the law entered into force, then the second decision of the Constitutional Court said that we can go back regarding financial investigation 5 years before the decision until now. So in the financial investigation, we calculate a lot the discrepancy between the assets the person had and the income of that person. But that calculation includes the assets which the person had at one point but doesn't have it anymore. So you can see that the person sold the house and then bought a house and then sold it. Then they actually bought cocaine and they sniffed it. So it doesn't exist anymore. So because the assets do not exist anymore, but in order, in such situations, we can take other assets that the person gained before, but is not within the period of the financial investigation. So we tried several times in the court and we failed, because when we did calculate, but we didn't have the assets to confiscate. So we formulated our approach in such a way that they had to pay for that property, for the assets, because if they don't pay, we have the legal power of 10 years, and we can, based on that, confiscate the assets, even the assets that the person had got at the stage when, let's say, the person's mother died and he inherited that property. So that's the process we tried, so that the person cannot have the legal assets, but if you don't find those assets that he gained through criminal activities, that he can gain, confiscate some other assets to compensate for the illegal assets. Now we think that it's a fair approach, but we still wait for the authorities to decide whether it's constitutional or not. Now I could mention also some other solutions that seem to be good, and I think we've been quite creative, and this may give a good idea not only to Montenegro but to some other parties. The human rights generally are important. So in the amendments to the law in 2014, we said that the financial investigation group completes its job when they collect information, evidence on income, on assets, and when we calculate the discrepancy, then the person who is under investigation must be informed about the results and give the person the possibility to decide. Although that stage of investigation was a secret, once it's completed, when we already have the possibility to confiscate the assets, and at that point it's not dangerous if the person finds out about the results. So the person is informed about our results and they can give a statement on that. What does this mean? It means that before we start with the civil proceedings, if the person provides or explains how he got that property or has a legal ground for that, that we can check and see that it's a property of legal origin, then we can reduce the amount calculated. But we have never had such a situation so far. No one has ever provided any documents to justify this discrepancy between the assets and the income. We're still waiting for such an example. We haven't had it so far. A second thing is that it was interesting to see, because Slovenia has a population of 2 million and we have around 200 prosecutors. We work in 12 different prosecutors' offices, but the primary thing is prosecution, of course. So we resolved the situation in such a way that the Special State Prosecutor's Office established a unit called Civil Financial Unit. That was in 2014. So in criminal cases, in addition to criminal cases, we work with civil cases. So all the prosecutors throughout Slovenia can decide to carry out financial investigations. And that's the first phase. They establish a financial team. These are compulsory financial teams. Prosecutors never do that on their own because they don't have enough knowledge or information for that. So the financial team includes representatives of the police, financial administration, and if necessary, representatives of the anti-corruption agency and the agency for prevention of money laundering. Sometimes some other institutions, but these 4 institutions are the most important. They have to have their representatives. And the most important ones are those coming from the financial administration, because they applied the methods prescribed by the OECD and are clear and easily understandable. The prosecutors cannot do those calculations on their own. Investigation is a different thing. So all the prosecutors' offices do those investigations, and once they result in identification of this difference between the assets and the income, then it is forwarded to our special prosecutor's office. That is my department that I manage, and during these years, since 2012, we've been trained for this segment, and we have also employed true specialists, to experts for civil cases. So there are 3 or 4 prosecutors who represent the cases before the court, and we have this specialized knowledge and we put it in this small segment, because otherwise it would be very difficult for all prosecutors to be trained for all these, both these areas, the criminal proceedings and the civil proceedings. And I can say that civil proceedings are very difficult because people do their best to keep their money, and when we have the court hearings, they hire the best lawyers firms. A lot of these lawyers, there can be several firms representing just one person, so it's a tough fight. And when the situation is clear, and that's actually when we confiscate assets acquired through obvious criminal activities, when there was drug or prostitution, because we have really people who have dealt with these criminal offenses all their life, and they never had any legal income. So it's easy with them. It's much more difficult when you have persons who have worked all their life in high positions. Very often they did have good income, because the priority in our procedure is that we never confiscate something that is the subject of the criminal procedure. So when there is in such situation, we deal with in rem situations with a small part, a small share. This is the property that is known to be acquired through illegal activities, but we could not identify it based on the criminal offense, because if it is based on the criminal offense, then it's located there. So now I want to conclude that we are intensively working on identification of criminal proceedings that would be interesting to start with the financial investigation, then proceeded in rem proceedings. So we also do our best to improve our procedures. We do analytical job, data processing, and we try to see how our law can be amended. Our law has only 58 articles, and I must say that we can easily apply it, and we look forward to all the challenges ahead of us. So if there are any questions, I'm ready to answer them. Thank you. Based on your presentation, we could hear how sensitive this issue is, and we have very limited potentials in that field. Are there any questions for any of the participants of this panel?
Jedan sekund, evo, Vanja traži mikrofon sam.
Vanja ni...
Dobar dan, hvala vam puno na vašem učešću i na tome što ste dijelili vaše iskustva sa nama. Čuli smo i od gospodina Lininga i od gospodina Hicksa preporuku da se počne sa manjim i jednostavnijim slučajima. Ono zbog čega smo mi zabrinuti je da će ostati na manjim i jednostavnijim slučajima. Da li se tako nešto desi u Sloveniji? Na koji način ste odlučivali koji su to prioritetni predmeti? Razumijem da ste pokušali da to primijenite od 90. godine, ali da u tome niste uspjeli. Međutim, na koji način odlučujete šta su prioriteti? Da li imate neku granicu preko koje se ta imovina oduzima? U Crnoj Gori, na primjer, se predlaže da ta granica bude 50.000 eura. razlike između prihoda koji se mogu dokazati i imovine koja je stečena. Nas brine da to možda može da ostavi preveliki prostor za djelovanje tužilaštva u smislu da onda maltene svi građani budu izloženi tome zakonu, što suštinski nije njegova intencija. Pa me interesuje, pogotovo od vas iz Slovenije, jer vi razumijete kontekst u kome mi funkcionišemo na Balkanu. Kako ste vi tome pristupili? Da li ste i vi krenuli od manjih slučajeva i na koji način ste se bavili time da ne dođete u situaciju da budete selektivni i da birate neke predmete koji su možda jednostavniji za izvesti, ali čija društvena opasnost i šteta po javnost, odnosno po javni interes je manja? I za gospodina Hicksa jedno pitanje. Kada je u pitanju međunarodna saradnja.
So for Mr. Hicks, as for international cooperation, as you have IMREM system, when it comes to international cooperation, we saw that there are some problems in international relations meaning international cooperation. What is your experience on INREM proceedings and international cooperation? And hypothetically, if Montenegro asks Great Britain to take a look at some of our transactions of our nationals over there through institutions, financial institutions there, would it be productive? Is it possible to serve that request?
Okay, there's quite a lot of questions in there. Let me just start with the human rights question. It's an important difference in the UK when we moved to the new Act, that it was no longer possible to use frozen funds to fund the defence. And so people who are being defended in the UK must rely on the public defender. But certainly at the time, the public defender was well resourced, and I am in favour, from a human rights point of view, that public defenders are properly resourced so that they have at least the level of skills as the prosecutor. And we have a system, an adversarial system in the UK to make sure that that is the case. And public defenders should be properly resourced so that the prosecutors are as good as they can be. The better the public defender, the better the prosecutor, the better the police, the better the justice. So I'm in favour of a strong public defender being in existence, but it should not be able to use, the defendant should not be able to use the frozen funds that they may have got from committing crime or that may be the proceeds of crime. So they should not have access to those funds, because the experience of the UK during the 1980s and 1990s was that defendants would use up all of the money they had made from crime to defend themselves from the charges of the prosecutor, which did not deliver justice. And that was a key change for the UK law in 2003. How do we select cases? Well, and this would be my recommendation to Montenegro, we started with the cases that were already in the process, already being investigated, perhaps already in court, and to use the new powers on those cases. And I would also recommend the thorough review of existing casework to see what has worked and what has failed in the past. So you have an understanding of how your system responds to the circumstances with which it is dealing. So how do we prioritise cases? Well, deal with the ones that you already have. The UK system, when it first began, was hierarchical, which meant that you had to start with a criminal investigation, and that had to be exhausted before it could be passed for an in rem investigation. And that was the system we chose to adopt at the beginning. I'm not sure it worked very well, because it's always possible to investigate criminally a little bit more. So it's very difficult. In all systems, I think, the start of a case and the closure of a case without a result is quite a difficult process to manage. And finally, in terms of international letters of request, it is certainly the UK's view that international letters of request in criminal cases should include the possibility of in rem litigation, if that is possible. So that as a matter of course, the letter of request in a criminal case requesting criminal restraint or freezing of assets also contains the option to freeze through an in rem process, if that is possible in the receiving country. And that is, again, quite a complicated area. We would like prosecutors across Europe to routinely allow their request to be done in personam and in rem, and there is advice available from Eurojust about how to do those requests. I hope that answers those questions.
Hvala lijepo. Je li ima još neko dodatno pitanje?
Thank you very much. Is there any additional question or any question you might want to ask? Oh, yeah, there was a question for Ms. Lipovšek, I believe. Was it?
Da.
Yeah. Yes, in our situation, I'll be precise. I'll tell you what we have in the law. So financial investigation can be conducted if we have predicate or pre-criminal and preliminary preparations, and if we have indications that people have some illegal proceeds over the value of 50,000 euros. So this threshold is, the value of 50,000. We believe that we should lower this threshold. Because the threshold limits us to order financial investigation. It is normal that we had the possibility to to come up with that. We found out that this the mismatch is much more than 50,000, definitely and easily, but we believe that 50,000 euros for our country, it is too high threshold, judging by circumstances we live in. So we believe that through this case, we or police, we have to establish that whether or not the threshold or the mismatch is more than 50,000 euros. So we suggest to lower the threshold. We said 10 to 15,000, but then the question is, if it is 10 to 15, and then if we can do away with 10 to 15, then why do we need that at all? So what do you think, that it would be a witch hunt of a kind? As for the threshold, I think that if we during the criminal proceedings see that in pre-criminal procedure we see that we can go for financial investigation, then we should be allowed to go for that without that threshold. So one of conditions is that the mismatch between income and the property should not be the product of the criminal offense. Should be we didn't have witch hunt with this 50,000. You know, when we applied this benchmark, we always found a criminal offense in the background. So it is just the threshold which gave us leeway or opened the way to start a financial investigation. Thank you. Are there any